that now. Devika, if you want to start the recording, please. Good morning, good evening, everybody. Thank you for joining today's call. We are really pleased to have a great team from Khaitan Company who is going to go through our second in a series of digital legal roundups. The idea here is that there's a lot of policy making that occurs in India's judiciary, and it often gets missed. And therefore, we'd like to have the opportunity to sort of catch up on particular issues. Before we go, I want to just thank Paku Khan and Aloy from the Khaitan team for really pulling this together, identifying issues, to the larger Khaitan team as well for their insights. Should you have any questions, please feel free to put them in the chat. In terms of flow, at the end of the call, we will have members come online and ask those questions. And of course, we will also be more than happy to introduce you after the call if you have follow-ups. So with that, let me set a few ground rules. This meeting is going to be recorded. It's going to be public. There are slides that we will make available afterwards. And with that, I want to hand the microphone over to our Wolf Blitzer, no less than Arshad Paku Khan. So thank you, Paku, for doing this. And sir, the microphone and screen is yours.
Jay, thank you so much, and to all of our audience and to the digital economy members of the USIBC, thank you so much for joining. As Jay said, we're trying to keep this in the form of what we call a nightly newscast, and we've assembled a team of our partners to give you short but practical guidance on some of the latest judicial and other legal developments in India that we think you need to know about. And so we hope this format works for you well. Just one thing I wanted to add is we did the first one of these in late March and it went really well. And I think the idea is to do these every few weeks. Obviously, the pandemic intervened in a very, very sad way. We hope that everybody is doing well and will stay safe. So let's go to the next slide. And let me just introduce my colleagues very quickly from left to right and from top to bottom. We have Anushka Sharda from our Delhi office, who's a litigation partner. We've got Supratim Chakrabarti, or as we affectionately call him, Supro, from our Calcutta office, and he specializes, among other things, in data privacy. Tanu Banerjee from our Mumbai office, who specializes in TMT. And then going to the bottom row, we've got Sanjay Khan Nagra from our Bangalore office, who does a lot in the way of cryptocurrency, private equity, and corporate work. And then finally, the last of our substantive speakers is Vinitha Krishnan, a director in our direct tax team in Mumbai. And I'm the fellow at the very bottom left. I'm actually a competition lawyer. And I think my role here today is to play moderator. And generally, my other role is that I'm close to the same time zone as Jay because I live in the Bay Area, so we communicate quite well. So that being the case, let me go quickly to our outline. We're going to cover 5 topics and we're going to go around 4 or 5 minutes each. First of all, we've got Anushka taking on the issue of intermediary liability and the legal developments around the new IL rules, as we call them. Second, we're going to have Supro covering data breach and cybersecurity incident reporting. It's something that all of us are facing, frankly, now on a daily basis. Then we're going to switch gears a little bit and go to some cinematography amendments regarding movies, essentially. And Tanu is going to take us through that. Sanjay from our Bangalore office is going to talk about the latest and greatest in cryptocurrency legal updates and some clarifications that the Reserve Bank of India has issued. And then finally, Vinitha is going to take us through updates regarding digital tax. So that being said, Anushka, let me turn the program over to you to talk briefly about intermediary liability.
Thanks, Paku. So I'm going to cover the latest developments in court pursuant to the rollout of the IT rules in February earlier this year. Now, to say the very least, the rules have created a stir in the industry. Considering the wide ambit of the rules, they have been challenged by stakeholders, including social media intermediaries, their users, news publishers, OTTs across various state high courts across India. Now, while the challenge petitions have been filed and notices have been issued to the government to respond to the petitions, it is in fact only Kerala High Court which has granted a stay against any coercive action being taken against the petitioners, namely Live Law, which is a law reporter, and News Broadcasters Association. The other high courts have in fact refused to grant interim protection, and Delhi High Court has taken a step forward and asked the social media intermediaries to comply, failing which they have mentioned that they may lose safe harbor protection. So the petitions are still alive, but this is the current status of the petitions. Now, considering the number of petitions pending across various high courts, the government of India has filed transfer petitions before the Supreme Court to consolidate the petitions and get a consolidated hearing before Supreme Court. This transfer petition is scheduled to be listed tomorrow, and which will throw more clarity on what the way forward for all these petitions will be. Now, I'm just going to touch upon one very significant judgment which has been issued pursuant to the IT rules. That is in the case of X versus Union of India. This judgment significantly impacts intermediaries and search engines more particularly, and has in fact been challenged by Google before the division bench of the High Court. Now, why is this judgment significant? Because this judgment does not only give an order in the facts of its case, but also lays down a template order which may be passed by courts in future cases relating to removal of offending content. And what the judgment says is that it is passing this template order so that its orders become more effective and prevent offending content from resurfacing on the World Wide Web. Now, there are the important ingredients of the template order which have been challenged by Google in the division bench. Before the division bench are, firstly, the template order requires an intermediary to remove offending content within 24 hours of receipt of a court order. Now, the challenge is that the IT rules in fact grant an intermediary 36 hours for compliance. And therefore, the court may not, through its template order, confine those 36 hours, which are already a very confined period of time, to 24 hours. Now, the second important feature of this order is that it requires search engines to endeavor to deploy tools to automatically remove the offending content. Now, the question before the appellate court is whether such obligations can in the first place be cast upon search engines. This is because the IT Rules 2021 cast the obligation of proactive monitoring of content only on significant social media intermediaries. Therefore, the question raised by Google in the appeal is that is the characterization of a search engine by Delhi High Court as a significant social media intermediary proper, considering that a search engine only indexes information hosted by other platforms and does not itself host any information, and needless to state, does not enable interaction between users. Now, the other significant judgment which has been delivered by Supreme Court in the last 1 month is that in the case of Ajit Mohan versus the Legislative Assembly of Delhi. Now, maybe people are aware there were some riots in Delhi in February 2020. Now, post these riots, the Legislative Assembly of Delhi constituted a committee to detect what happened and formulate recommendations to ensure that it does not happen again. There was a writ petition filed by Facebook challenging the summons issued by the committee for Facebook to appear before it. Now, Supreme Court gave its judgment in the last 1 week or so, where it has held that the intermediary is required to appear before the committee. However, the intermediary cannot act as a prosecuting agency and cannot hold people guilty or direct the filing of a supplementary charge sheet. Were this to happen, Facebook can refrain from answering such questions, and Facebook can perhaps even challenge such conduct before courts once again. Now, I think what's happening with Twitter is well known in the news media, and it's stated in the slide. With this, I'll hand over the baton to Paku.
Anushka, thank you so much. And let me turn it over to Supratim to talk about something that's frankly in the news every day all over the world, and that's data breaches and cybersecurity incidents. And I think, Supro, one of the things you're going to talk about is something called CERTIN. So over to you, Supro.
Thank you. Can we move to the next slide, please?
We've moved to the next slide.
It's still showing the IL rules.
Not for everybody. It may just be buffering. We see it fine.
Okay.
Go ahead, Super Team.
Sorry. So for my screen, it's still showing the old slide, but I'll just start off. So, data breach reporting, per se, India does not have a dedicated legislation on data privacy and protection. So we do not have a requirement per se to notify data subjects when there is a data breach. However, there are certain provisions under the Information Technology Act and the certain rules that are there. And that says two things. One is there is one category of in cybersecurity incident where you may report. And then there are certain enumerated categories where you must report to the CERT which is Computer Emergency Response Team of India. And you need to give certain enumerated details which are there in the form. That's the present day scenario. Now, interestingly, what happened in January 2021, the CERT came out with an advisory amongst various things. What they also mentioned is that if there is a data breach, then or data leak, then you should immediately report to CERT. So therefore, effectively, what's happening is any category of data breach, you should report to CERT. And the second thing which it says is that you should inform data subjects about the breach and what steps have been taken and what they can do to reach out to you. Now, this is, I would say, earth-shattering from an India context, because the present day Information Technology Act, the rules do not talk about it, firstly. Secondly, even the upcoming Personal Data Protection Bill, that does not talk about data breach reporting in this manner. We have discussed this at length with Justice Sri Krishna Committee, and the way it is presented is a very graded approach. If there is a data breach, you assess whether data subjects would be harmed. You go to the authority, and the authority takes a decision whether this should be informed to them, considering the harm that could be caused or the steps that are to be taken. If it is catastrophic enough, they can also sort of ask to put up these details on your website. Even the authority can put up these details on the website. So you can imagine, like, this scenario is sort of fast changing, and unless this is challenged and someone really picks up this particular advisory and challenges, this seems to be becoming the requirement. And why are we talking about it today? Is because increasingly we're observing that CERT is sending notices to players who could have faced a data breach. And towards the end of that notice, innocuously, they are pasting the link for that advisory. So we thought it important for our members here to know about this development. Thank you. I think there's a question. We can take it now, Jay, or at the end.
Yeah, Layla, why don't you come on to screen and ask your question since we have a minute. Going once, going twice. Paku, let's keep going, and Layla will catch up on your question later.
Sure. Tanu, let's let you now talk about the cinematography amendment bill, and if you can take a few minutes to walk our audience through the highlights of that. And one thing I want to mention, some of you may not be seeing the current slide, but that should be taken care of in the recording.
Thanks, Pat. Hop in and then they see the active slide. Now it's changed. Tanu, go ahead, please.
Sure, I can't see the slide as well, but I'll start off. Okay, so the Ministry of Information and Broadcasting in India has introduced the Cinematograph Amendment Bill 2021, which includes provisions which were proposed in the previous 2019 bill and also takes into account some of the recommendations of the previously formed expert committees on the subject, that is the Mudgal Committee and the Sham Benegal Committee. The government has currently sought comments from the public on this bill. To look at just some of the amendments that the bill is proposing. Firstly, the bill proposes to categorize the existing UA category of film certification into further subdivisions, being UA 7+, which stands for Unrestricted Exhibition for People Above 7 years of age, and similarly UA 13+ and UA 16+. Now, this is a modification to the existing 4 broad classifications that are already available under the Cinematograph Act 1952, which are U or Universal, which stands for Unrestricted Exhibition for All Age Groups, UA, which stands for Unrestricted Exhibition except anyone below 12 years of age, A, which is restricted for adults only, and S, which is restricted for specific class of persons. Secondly, the bill proposes to prohibit recording or transmission of films through camcorders without the express permission of the owner. Violation of this could lead to imprisonment of 3 months and up to 3 years, or a fine of at least 3 lakhs, which could go up to 5% of the gross production cost of the film, or even both. Thirdly, the bill proposes to empower the central government to order a re-examination of a certification that has been already granted based on complaints that may be received from the public post-certification and post-release. Lastly, the bill seeks to increase the validity period of the certification granted by the CBFC to perpetuity from the existing period of 10 years. And therefore, this may do away with the process of renewal of certification after 10 years. Quick takeaways on this from a bill perspective, and of course, we're yet to see how this will finally shape up in the final amendment. But the new age ratings that the bill is proposing now is similar to the age ratings that are prescribed under the Digital Ethics Code, which is under the IT rules for digital media platforms. And therefore, it seems that the government wants content across all platforms to be categorized similarly. Penalties for anti-camcording provisions are very heavy in nature. And it does seem that it will add teeth to our existing anti-piracy provisions under the Indian laws. As far as re-examination of the certification is concerned, I think filmmakers are criticizing it at the moment, and there are concerns around revisionary powers of the central government to the extent that a certificate which is already granted can be re-examined and the matter could be reopened. In parallel, the government has also amended the rules under the Cable TV Network Act. Now, the Cable TV Network Act governs television channels in India in generally. Now, the amended rules create a 3-tier grievance redressal mechanism for the broadcasting space, which is interestingly very similar to the 3-tier grievance redressal mechanism, which is prescribed under the IT rules for digital media players. I think just quickly what the 3-tier mechanism entails. The grievance redressal at the first level has self-regulation by the broadcaster itself. At the second level, it has a self-regulatory body which is to be constituted by broadcasters themselves, and this regulatory body has to be registered with the government. And at the third level is the interdepartmental government, which will be constituted by the Ministry of Broadcasting itself. Final notes on this overall segment. I think through the amendments to the Cinematograph Act and the Cable TV rules, it does seem that the government is aiming to replicate provisions which were prescribed under the Digital Media Ethics Code into the other legislations which govern the theatrical films and the satellite world. And overall intent seems to be to bring parity across all mediums of content. That's it from me on this segment. I'm going to hand this back to Paku.
Thanu, thank you so much. And now let's turn to Sanjay in our Bangalore office. He's one of the leading experts on cryptocurrency. And I think, Sanjay, it's fair to say that the government of India, or GOI, as we're referring it in the slides, is a little bit skeptical about crypto. Is that right?
So I think this is one topic on which everyone in the audience and their respective countries would be able to relate, because countries across the globe have been grappling with this problem of how to regulate cryptocurrencies, whether to regulate or ban, right? And India is no different. India, in fact, has a compounded problem of having capital controls. So for the viewers in audience who are not aware, India strictly regulates the money that comes in and goes out of India, right? It is not a closed economy like some of the other countries are. It is a semi-closed economy. In some time in future, India will. It is a stated objective of the Reserve Bank of India, which is India's central bank, to open up India's economy, similar to say a Singapore or US and other countries. But as of now, India is a semi-closed economy, and therefore you cannot really bring any amount of capital if you want to. You cannot take any amount of capital if you want to take out. And as you can imagine, cryptocurrencies are just the antithesis of it. And therefore, India does not have a problem only of cryptocurrencies. It has a problem of cryptocurrencies plus the capital controls. And that compounds the problem for India. I'll quickly take you all through what has happened in this sphere so far. Until 2018, India did not have any form of regulatory advice or anything else as such in the domain. The Reserve Bank of India on a couple of occasions had made general advisories that people should be cautious while investing in cryptocurrencies, but there was no regulation banning it or regulating it as such. In 2018, there was a circular from the Reserve Bank of India to the banks, because the Reserve Bank of India governs all the other banks in India. And there was a circular from the Reserve Bank of India to the banks that no banking service should be provided to any cryptocurrency business. And that effectively meant that cryptocurrency platforms, exchanges, and other service providers in the similar space could not operate in India, because you do need the fiat to crypto conversion services. And therefore, the crypto exchanges in India moved to a more P2P model, or as we call it, crypto to crypto model, or where people are inter-se trading without the money moving through the exchange. And that continued until last year, when the Supreme Court of India struck down this particular circular and then stated that this circular is probably too much for the problem it is trying to solve, or in any event, if a ban has to be imposed on cryptocurrencies, maybe there should be a legislative ban and there should be a process under which the government of India should decide whether to ban or not. After last year's Supreme Court ruling, there is once again a regulatory vacuum, and there is no further regulation or circular or any sort of guidance from the government on whether cryptocurrency businesses are permitted or prohibited. In the process, what has happened is that banks have started providing services. They had started providing services to cryptocurrency businesses after the Supreme Court ruling in March 2020. That continued until early part of this year, when a few weeks earlier, the Reserve Bank once again clarified that there is no banking prohibition. At the same time, they warned the banks that if you are providing services to cryptocurrency exchanges, you must be cautious of all the KYC, anti-money laundering, and other aspects of money movement. And in a way, it is seen as if RBI is cautioning banks that, look, there is no regulatory prohibition on you to give cryptocurrency businesses any services. However, please be very, very sure of who you are serving. And that has put another degree of, if I may use the word caution in the minds of the banks. And therefore, at present, very few banks are willing to provide services to crypto exchanges. For the next phase, it is expected that the government of India will come together with some form of regulations. We do not know at this point which way it is going to swing. However, it appears that the central government is very keen to somehow figure out some regulation on it, whether because if you ban it completely, then people find other ways and means to deal in the same space, and therefore it is better that some form of regulation takes place. However, at this point, there is no clarity whether the government and the Reserve Bank of India would be able to come out with an effective regulation. And in the absence of any such effective regulations, investors at present are slightly cautious. Some of them are cautiously optimistic, and therefore they are investing in the cryptocurrency businesses. Some people are very, very optimistic that yes, there will be regulations. At this point, there is only a guidance from the government of India that people and the company should disclose in their annual filings what cryptocurrency holdings they have, and it is perceived as one of the ways by which the government wants to seek the data as to how much crypto is held by everyone, so that they can have effective regulations. So with this, I will leave it back to Paku. We can probably take questions on this in the question answer segment.
Thank you so much, Sanjay. And as Jay's just noted, we have a technology glitch, which I've not seen before. Some of us are seeing the advanced slides and some of us are not. So sincere apologies, but Jay, hopefully we can get the slides to the audience at some stage to make up for that. In the interest of time, let me pass this the baton over to Vinitha in our Mumbai office. She's our direct tax expert, and she's going to be talking to us about digital tax and significant economic presence and equalization levies.
Thank you, Paku. Good evening, everyone, and good morning. So just to give you a background, SEP is something which determines when a non-resident would have a taxable presence in India, even though they don't have any formal physical presence. India had a concept of SEP in its tax laws, but it is actually made effective from 1st April 2021. And there are rules which are notified. There are two limbs to the rule. The first limb is linked to the revenue threshold. So if there is a non-resident which has a transaction of goods, services, or any property with any person in India, or they are from a software industry, they give a provision of data software download in India, and if aggregate of the transaction or a single transaction for a particular financial year, which is typically 1st April to 31st March, if it is around USD 270,000, which is a very low threshold, then they can have a taxable presence in India. The second limb is for industry which is dependent on users like a social media. If they are soliciting business or engaging in interaction with users in India, and the number of users is around 3 lakh, then they can have a taxable presence in India. So what happens if you have a taxable presence? The income from these two transactions can be taxed in India, and it is deemed that the entire transaction is coming from India. And the tax can be as high at 43% for a corporate. And there can be corresponding withholding tax trigger for the payer. There are situations where SEP is not applicable. Say, for example, the non-resident is from a country, say US, and they are entitled to a treaty benefit. Then the concepts of permanent establishment under the treaty would still apply, and the SEP tax liability should not really arise. Also, India had introduced, to give you a background, a tax which was called as equalization levy, which is India's version of digital service tax, whereby a non-resident e-commerce operator required to pay around 2% tax in India. And if equalization levy is a tax which the non-resident e-commerce operator is required to pay, then technically the income tax exemption is there and therefore SEP should not be applicable. To sum it up, it really has an impact from a digital as well as in a non-digital sector. While the intent of SEP was to really, target a digital sector, but the way the provision is worded, even a plain vanilla US entity, sending out physical goods to India by way of export may be impacted. Also for a digital sector, say if it is a cloud computing sector or a video audio streaming sector, or a sector which is like based on a social media, or also what Sanjay had touched upon, a cryptocurrency exchange, for example, may also need to look into the impact of SEP. And the interplay between equalization and SEP, it's becoming more and more interesting, because whether a non-resident should pay a 2% equalization levy in India, or they should be subject to an SEP trigger, or they are entitled to treaty benefit, therefore the SEP is not relevant and they are subject to a gross basis taxation, say at 10% as royalty or FTS, needs to be closely seen depending on the exact transactions which they have with the Indian customer or the Indian user. The third thing which is very important is treaty benefit. It would be very common now, especially on the Indian export side, or a customer also insisting for a TRC even for an export sale, and have a comfort whether the non-resident is entitled to treaty benefit. And if they are fiscally transparent entities in US, it becomes debatable whether they are really entitled to treaty benefit. Lastly, one should closely watch the global tax deal developments in terms of Pillar 1 of OECD, where depending on the size of the MNC, there can be a tax profit which can be attributed to jurisdiction, and there can be some corresponding changes to all these tax laws which have been slated in the Indian tax law. Next slide, please. Very quickly on the equalization levy, while this law has been there in the Indian tax since last year, there have been certain clarification which was brought in the recent budget. Especially for a marketplace model, there was a debate when they are facilitating sales of a non-resident seller. They should pay equalization levy, which is a 2% tax, only on the consideration they receive, or should it be on the fee which they receive from the customer? It has been clarified, it has to be on the entire consideration. The only relaxation is if they are facilitating sales of an Indian resident seller. In those situations, they have to pay 2% tax only on the fee portion. And the third important clarification is in terms of an equalization levy, even if any of the transaction happens in an online mode, say whether an online supply or a service happens, either acceptance of an offer as you can see in the slide, or an order is placed online, consideration is paid, or the service or goods are actually given in online mode, any of the mode gets strict equalization levy is applicable. So to give you an example, even if Vinita is sitting in Mumbai, if I would, try and book something in US for a hotel booking, perhaps the US aggregator may need to pay an equalization levy in India. This is something, of course, which is highly debated in the Indian context. One has to really, closely watch and see what would be the real impact for the operator in India. And also the Indian payers are equally becoming, cautious because there are withholding tax obligations on them. That's about it on the Indian tax side. Over to you, Paku.
Vanitha, thank you so much for that update on the digital tax. And again, apologies for the glitches with the slides, but as Jay mentioned, we'll get those slides to you. And I think now let's move to the question and answer section here. We'll take a few minutes, and then I think Jay will close just as soon as we finish the questions. So audience, over to you.
Let me start a question, get the juices flowing, as they say, on cryptocurrencies. There's a market that's both exciting and discomforting for regulators. Can you give us sort of a high-level thinking of how the government of India views cryptocurrencies. Is it an opportunity? Is it a threat? Is it a combination of both? Give us some strategic or stakeholder context of how people are thinking about cryptocurrency.
Sure, and we have been involved in some of the processes with the government and organizations on this. I can tell you what is publicly known, and also some of the things that we have also seen, and where I personally think some direction will happen. Number one, the government of India has confirmed on multiple occasions during the budget speeches and otherwise, the blockchain as a technology is something that they are really keen on, and they are very supportive of any products that are built on blockchain as a technology. The government of India has also clarified, and there is a formal process that they have initiated for exploring CBDC, which is central bank digital currency, and so that digital currency of India as a country can be launched in various products on that. And there are various central government schemes, benefits which are given directly to the beneficiaries. Those schemes, etc., can really be used based on CBDC. So these two are absolutely the government is behind making these two a great success. The question about cryptocurrency, like I explained earlier, is multidimensional. There are inherent capital control problems in India, which make India not so ideal jurisdiction for regulating cryptocurrencies and permitting them, because then you need to figure out how will capital controls work. Second is the fact that India as a country has probably not the same level of technical infrastructure in the where regulation wise, if you have to have effective regulations, it is somewhat of a problem as compared to a smaller and well developed nations. So in that context, the view that is there, and a few government officials have made statements that they are keen to figure out a way in which cryptocurrencies can be effectively regulated, if not completely banned. Although there have not been any formal steps taken, or there is no formal announcement made whether or not they will ban or regulate cryptocurrencies. My personal view is it is not an easy judgment to make to ban cryptocurrencies, because the moment you ban anything like this, people find ways and means to trade in that commodity, in this case cryptocurrencies, in the parallel market, which is not good for the economy either. Secondly, India as a country has so much of exposure already in crypto that if you immediately ban any form of holding or trading in cryptocurrencies, you are actually the India as an economy will actually take a large hit, because everybody who's holding cryptocurrency in India, they will have to offload it at dirt cheap prices, and therefore it is counterproductive for India as an economy. And which is why the government is trying to figure out ways and means by which maybe it can be effectively regulated, and maybe there could be thresholds put, maybe there could be higher KYC requirements, maybe there could be entry barriers for only educated investors, or not retail investors. So, but I think it is some time away right now where we can see some effective form of regulations. One thing I must say and end my answer is that in earlier this year, a few months back, the government of India asked, and it's a formal requirement now, for every company to disclose in its financial statements if they hold any cryptocurrencies. Right? There is a formal column added in the financial statements. Now it is widely perceived that that will give Indian government a lot of data about how much crypto exposures do Indian companies have, and it is widely perceived that this data will then drive the decision, because if there is so much of exposure already, then it is important for the government to also realize and regulate it in some form, and that's really is the hope at this point.
Thank you. That's super insightful. I really appreciate that. Supro, I have one more question for you, sir, on breaches. So it's sort of a two-part question. One, you get a letter, there's a breach. We know these things are fairly commonplace. It could be very overwhelming if every instance you had to go and do a regulatory filing. And and then companies, of course, are always have reputational issues and other security issues to handle. What happens if you don't, send this information to the government? That's the first question. And what happens if where is this going? If you were to sort of project out where CERT-In is thinking about going in terms of breach assessments, do you have any insight of where the environment or terrain goes from here?
Right. I think two things here. Firstly, when you have a breach, if it is one of the breaches which is enumerated in the information technology rules, which are already setting out certain, specified items which you must report, it would be advisable to definitely report that. Okay, there is a form which is there. You just need to fill that up and send it to the CERT. And there is no hard timeline which is given. It is as soon as possible. So basically, there's some kind of leeway there. Now, what we're observing as a problem is that if by chance CERT picks that up as a news or through any other mode, that such a breach has happened and the reporting did not occur, okay? There you could face issues and questions, and they might come to you asking for the same set of questions. What we're observing as a change right now is this additional requirement to report any and every breach, because that categorization has somehow been blurred or obliterated because of the advisory that has been issued in January 2021. And a more difficult one is the data subject notification that such a breach has occurred, what we have done for the breach, how you can get further information from us, so on and so forth. Now, to that, I think the organization will have to take a call that whether to challenge that, or we have seen certain instances where it is not possible to have identified specific data subjects. So what they have done is basically stated that it's not possible, considering the kind of cyber incident that you're talking about, to identify specific data subjects and intimate them. However, we are reporting to you, here are the details. So that's what we are seeing. Where do we see this going? This could actually run counter to the Personal Data Protection Bill, which I just mentioned has a very different construct. It is clearly stating that the Data Protection Authority is supposed to decide on this, and you should not sit in judgment and go out to the world and say that we have been breached. This is a discussion that we have had along with the tech folks in several of these committee meetings, just Sri Krishna committee meetings, and we took a very conscious decision how to word that. Okay, so definitely, if it is challenged, it might be watered down largely. CERT had been very active during the COVID times in coming out with advisories. Probably this is one of such advisory where they went ahead and out of their way and made certain points. What's making things difficult is basically quoting of that particular advisory in the notice that you are getting, because there you will have very little wriggle room to say, oh, I was not aware of this, or this is just an advisory. This is a very, I would say, a smart way of putting it, that you should have looked at this particular advisory and followed what is written there. So I'll pause there. I don't know whether I answered your question.
Thank you very much. Aditya, you have a question, sir. Please come off mute.
Thank you, Jay. If you have other questions, we'd like to address them as well at this point. But in the meanwhile, if our member companies are figuring out a few questions for our panel, I might ask Anushka on the intermediary guidelines aspect, and understand that, what is the implications of a non-compliance nature? I mean, while we see a lot of things have moved on those terms, how do we feel if a social media company has not been, for certain reasons, non-compliant? What are the implications for it and going forward?
What the rules state in black and white is non-compliance means you lose safe harbor protection under Section 79. But moving on from there, merely because you lose safe harbor protection doesn't mean that you are going to be penalized for the content on your platform. Even after that, it needs to be established whether you, what was your involvement, what was your negligence, or for instance, what is your culpability for that particular crime which may have been committed on your platform. So that's one. And two, I think I would like to take this opportunity to also clarify, one issue which has been doing the rounds. Non-compliance with the IT rules does not immediately amount to blocking in India. So blocking will only take place in case your platform's usage is such that it amounts to a threat to India's sovereignty or national security. There are 5 categories of cases in which, pursuant to which your platform may be blocked. But merely because you may not have appointed the officers required under the rules or may not be retaining data for 180 days, post termination of the accounts or removal of the content, it does not immediately mean that you'll be blocked in India. I hope that addresses your question.
Yeah, it does. Thank you very much. Absent any final questions, if I could ask, I see Paku's on the screen. Aloy, if you can come on as well. I'd really like to thank the Khaitan team for this really insightful information. We do apologize, there were some technical glitches. We'll get the slides to everybody, and the recording should be accurate, and we will make that available. In the meantime, Paku, Aloy, I really appreciate all the hard work. Anushka, Supro, Tano, Sanjay, Vanita, this sort of expertise, I think, adds a lot of value to what we're doing. I really appreciate the detailed attention, and I would offer up to the participants and members on the call, we'll be happy to connect everyone to Khaitan and experts as well. So do feel free to reach out to us. And with that, Paku, I'm going to hand that over to you for the final word.
Jay, thank you so much. And I want to thank my Khaitan Co colleagues, as well as Aloy on the production side who made all this happen. And most of all to the audience, we want to thank you. We're trying to make this as practical and as user-friendly and frankly as timely as possible. So please do let Jay know your feedback and also let him know if there are any ideas that you want for us to cover on Indian judicial or legal developments. And with that, I think we're going to close. So thank you so much, and everyone be safe, please.
Thank you again, and be well. And as they say in Hollywood, it's a wrap.
Bye.